Well, hi, I'm John Dearie, and welcome to our new series, Face to Face, in which we'll be talking about specific areas of accidents, maybe for you as a client or as a potential client that would be interested in that particular legal subject. And we'll get started with on the subject of construction site accidents, a very important and frequent occurrence, unfortunately. And the attorney in our office that handles that is someone that many of you will be familiar with, and that's Tom Boyle. Tom, welcome and good to see you.
John, thank you for having me.
Let's get started on this important area, construction site accidents. What's the definition of what that means?
You know, a construction site accident is something could be as basic as an employee goes onto a job site and he trips and falls over something that's on the job site. He could be hit by a delivery truck. There's many different kinds of construction site accidents that happen, especially in New York State, with the varied construction sites we have.
I know the law deals with a couple of different important statutes and sections, and what are those?
Most important ones for construction workers in New York are New York Labor Law Section 200, 240 sub 1, and 241 sub 6. These laws put additional responsibilities onto the owner, developers, contractors on job sites for the protection of the safety of any workers that are on a construction site.
Generally speaking, who is primarily responsible for the safety of a work site area that 2 or 200 workers are doing their individual trades day after day?
In a general sense, the owners have responsibility in addition to a contractor, or more specifically, a general contractor on a job site. Additionally, if if you're working for a subcontractor, they have additional safety responsibilities. Every contractor, every agent of a builder on a construction site has safety responsibilities.
When you talk about a construction site accident, it means by definition that the person was employed, was doing their work there. So that comes very close to the workers' compensation program. And it's been my sense over the years that many workers don't understand the distinction between a so-called third-party construction site accident and a workers' compensation.
Sure, there is a lot of people, it is very easy to get confused on that. Anytime somebody's hurt on a construction site, it absolutely gives rise to a workers' compensation claim. But not every accident gives rise to a third-party action. There's many different kinds of third-party actions which would arise out of any kind of incident. We've got a brochure here which provides a lot of information, different examples as far as where there might be a workers' compensation claim that would not necessarily give rise to a third-party action, and vice versa.
Just maybe an example or two. Let me perhaps throw one. Workers are up on a scaffold site, maybe 20, 30, 40 feet, and a car comes along and crashes into it and they wind up falling. Well, under those circumstances, they're injured on the job, so of course they're eligible for workers' compensation. But in that particular example, whoever was driving the car or the truck that crashed into them that caused the accident, that's the third-party action. Maybe you have another one.
Well, even looking at that example, there could also give rise to, you have to look at how the scaffolding was constructed. There might have been an issue with the scaffolding, or anytime there's work involving a height differential, whether it be somebody working at a height, or say somebody's working from above and a piece of material falls out of their hands and hits someone from below. Those are all examples of cases that would be specific labor law cases. Anytime somebody's hurt involving a height differential, there nearly always gives rise to some kind of third-party action.
In analyzing it, it seems like it's fairly close call between what is a workers' comp and whether the individual workers' comp they're always entitled to, whether there's a third-party action. I guess it takes some experience in looking at and seeking to make that differentiation legally as to whether in fact there is a third party.
Without question, you need to have an attorney that understands the different codes, whether it be an industrial code violation for 241 sub 6 or the specific applications under Labor Law 200 or 240 sub 1, because these rules, they're all very nuanced and they're very open to the interpretation of the court. So you need to make sure that somebody really understands what the situation was and what laws really apply.
You made reference to the issue of height, And I know that's important, and you know, you can come along and look at any construction site and see a crane up 40 feet or 400 feet, as well may be in the high-rise construction. So not only with cranes, but just the issue of heights. So in other words, someone obviously falls from 2 or 3 stories, and if someone falls off a ladder, are they both involved with height falls, and then does the statute protect them?
It depends, obviously, on the specific circumstances, because typically 240 sub 1, when you're looking at the height differential, you have to show that there were certain safety devices that were supposed to have been provided that weren't, or there was a failure of a safety device, something along those lines. So just because somebody falls from a height does not necessarily give rise to it, but you need to, again, look specifically, applying the facts, what should have been there and what could have prevented this accident from happening. And that's how you really know whether you've got a case from an elevational differential.
Issue we've spoken about for years is the statute of limitations. Now, let's talk about what that is, and also what is the statute of limitations on a construction site case.
The general rule is that the statute of limitations in New York State for any kind of personal injury matter, including a construction site accident, is 3 years. There's, of course, like any rule, there's always exceptions. In a case when you have an action involving a municipality, whether it be the city of New York, the state of New York, a notice of claim has to be filed within 90 days of that accident happening. And then there's other rules which apply as well. You have to bring an action against a city entity within a year and 90 days. You have to bring an action against a state entity within 2 years. And there's various entities, and the rules are changed for each of the different entities. There could have to be a case that goes into suit within 1 year of the action actually happening. These rules need to be applied very specifically.
So what it sounds like your recommendation is, if you've been injured on a job site, you better move quickly to get some kind of legal direction and assistance.
Absolutely. First things first, when you're hurt on a job site, the first thing you do, obviously, is seek medical attention. Report the accident to your employer and let them know what happened. You may want to also try to get photographs. Everyone on a job site these days has camera phones, and the best time to get photographs of the incident is right there on the site. You might not be able to take these photographs, but you'll have a friend or a coworker on the job site. Have them take these photographs, and you want to do whatever you can to get to safety, obviously. Once you've had a chance to seek medical attention, you absolutely want to contact an attorney who can get somebody out there to investigate the job site and protect your rights as soon as possible.
When you're talking about taking a picture, you're really saying, let's preserve the condition that created the accident in the first place. And so what advice might you give in terms of, for either co-workers or an individual that's injured, in taking a picture, what should they be thinking about doing?
You know, get as many pictures as possible. We always recommend you want to get them from a bigger point of view. A lot of times people tend to get pictures from a very up-close perspective. Get as many pictures, because you really need to preserve what the site looked like, and because absolutely after an accident happens, they're going to clean up the accident. They're going to make sure that whatever evidence is there is gone afterwards.
So when you're saying about that, you're talking about if, for example, let's say a co-worker left a toolbox in a pathway, and another tradesman came along and tripped over it and, let's say, broke his or her ankle. Not only do you want to get a shot of the toolbox up close so you get a sense, but you want to get a further away picture showing the pathway as well as the positioning of where the toolbox was at the time of the accident. Is that what you're talking about? Get a broader perspective as well as an uptight one.
Absolutely, because the broader perspective always also allows you to see the general condition of a work site. Because as you mentioned earlier, with a walkway, if a walkway is involved, that comes into play with certain industrial code violations, or whether a work site is involves other industrial code violations. The more pictures that you can get showing the broad spectrum of this work site, the better.
You mentioned before about the workers' comp, and I think some mistake often that is made by an injured worker is they have a tendency to do a lot of talking right at the site or immediately after the injury, as they may be waiting for medical attention or whatever. And I think it's very important that they understand that it is better to say nothing or very little than starting to talk about it, because statements can be ultimately used against them that can be very injurious to their case.
Absolutely. Without a doubt, soon after an accident happens, you're going to get a phone call from the insurance company, somebody looking to get a statement from you, somebody looking for you to fill out an incident report. You are under no obligation to speak to them, to give any kind of recorded statement. They're not looking to help you. They are looking to limit their exposure. They want to limit the damages and see what your injuries really are. They come to you pretending that they're there to help you, but they are in no way trying to help you.
You mentioned also about a municipality. For example, if the city of New York is constructing a facility and you happen to be working at that site and you're injured, and the funding is clearly done by the city of New York, and you're injured, that's where that 90-day period comes into play, where you've got to file the notice of claim within that time period. I believe it can be a little misleading also if you have a construction site where the city of New York may be one of a number of different financial supporters to that particular project. So if you have that situation and a person isn't sure, they could possibly wind up forgetting about the 90 days and thinking it's 3 years and lose out if they wind up finding out the city of New York may have been contributing 50 or 70%. And that goes for the state of New York too.
Absolutely. And oftentimes you'll see joint ventures. The city might be working on a project on a certain aspect of it. The state might have another portion of responsibility. As we know, there's many different city agencies. The city of New York there's dozens of agencies that do work, if not hundreds of agencies that do work in the city of New York. And the ones that you have to put them each on notice as far as whether an accident happened, when it happened, and what actually happened. You can't just let the city of New York know about it. You need to let the actual agency that was involved in this construction know about it.
Tom, we're going to catch our breath and we'll be back with part 2 of our conversation on construction site accidents, part of our series, Face to Face.